The witness who will break him isn't a scientist, a cop, or a paid expert. It is his mother. That is the promise hanging in the air as Courtroom 6 comes to attention, and a 17-year-old named Tyler Grayson walks in with the careless swagger of someone who believes rules are for other people. He lets out a thin laugh when his eyes pass the first row, where the victim's mother sits, and the sound is a paper cut you somehow feel in bone. Judge Celeste Monroe watches from the bench with the kind of composure that makes people stand straighter. Ada Aisha Coleman rises, mid-40s, steady as a metronome. "The people are ready, Your Honor." The words are simple, but they land like the first step onto a bridge that will hold. Outside this room, the night that began, it is still playing on a neighbor's camera. Rain needles the lens. A hooded figure slips into frame and does not hurry, hands tucked, the right shoulder ticking to a private rhythm. The timestamp burns in pale digits. Hours earlier, in a warm classroom, Dr. Lauren Whitfield wrote a single word on a whiteboard: empathy, and underlined it once with the care you might use to smooth a child's collar. She smiled the way good teachers do, with her whole face, as if the word could be an umbrella big enough for every storm. Somewhere between that gentle underline and the slick sidewalk, the idea of empathy became a target. Back to the present. Margaret Whitfield holds her daughter's gray scarf tight enough to leave knit marks on her fingers. A pulled thread trembles with each breath. Detective Marco Alvarez sits in the second row, a notebook soft at the edges from being opened too often. The kind of cop who chews facts until they swallow themselves. On the defense side, Evelyn Grayson, Tyler's mother, clutches her wrists, thumbs circling the same spot, a woman trying to sand down a splinter only she can feel. Richard Grayson, the father, keeps his jaw locked and his eyes on the judge, as if neutrality might work like bail. The clerk reads the case caption. The language is formal, ceremonial, like setting plates before a meal no one wants to eat. Aisha steps toward the jury box, not to perform, but to arrange. "Members of the jury," she says, and the room quiets, as if sound itself has been advised to remain seated. "The law will ask you to judge conduct. We won't ask you to guess his feelings. We will show you what he chose." Her voice is deliberate but never loud. She moves in contrasts. A teacher who made room for other people's pain so it wouldn't spill, and a teenager who treated other people's lives like levels in a game. The comparison is a scalpel, not a club. You can feel the cold edge before it cuts. Tyler hears the word empathy, and his mouth tilts in that same thin, private smile. If contempt had a wristwatch, it would keep time by his pulse. He leans back until the chair complains, a boy wearing adulthood like a borrowed suit, already wrinkling it. Judge Monroe's gaze slides to him and back, a lighthouse sweep that does not blink. The bailiff's shoes whisper over the tile. Jurors settle. Number 4, a school counselor by the look of her cardigan and the patience in her posture, studies the defendant the way one studies a weather map. Not for what it says, but for what it refuses to say. "The evidence will be straightforward," Ayasha continues. "You will see him arrive. You will see what touched him and what he touched. And you'll hear, at the right time, from the one person who knows the cost of protecting a lie, the defendant's mother." The sentence lands with a hush, a controlled detonation. Evelyn closes her eyes, a flinch that travels only as far as her lashes. Margaret inhales through the scarf, as if trying to borrow her daughter's last warmth. There is a question hiding under the furniture of the room, a question old as law and young as this boy. How do you laugh at the word that could have saved you? It doesn't need an answer yet. It needs a stage. The stage is here. The record light is red. The clerk stamps the first exhibit. And then something small fractures where only attention makes it visible. Tyler taps the base of his chair with the toe of his shoe. Tap, pause, tap, like signaling a co-conspirator the rest of us cannot see. Juror number 4 notices. She draws a tidy box on her legal pad and writes one quiet word inside it. The word that tells you a mask is already slipping. Smirk. The memorial fills the gym like a held breath. Folding chairs in careful rows, a banner strung over the stage. Mind matters. Students clutch paper candles. Faculty pin white ribbons to lapels. When the mic passes to a small girl in a denim jacket, she doesn't look at the crowd. She looks at the floor and says, clear as a bell. Ms. Whitfield taught me how to breathe, not how to ace a test, not how to win a fight, how to breathe. The line lands like a verdict the whole town is willing to sign. Principal Rebecca Sloan speaks of metrics, fewer referrals, calmer halls. But the numbers sound like shadows beside the single sentence that matters. A teacher who made room for other people's storms. A classroom that was a harbor. A kettle in room 214 that hissed softly after hours because cocoa can be a treatment plan. In the back row, a boy wipes his eyes with a sleeve and nods, as if marking attendance one last time. Cut to the house 3 blocks away. Margaret Whitfield turns off a whistling kettle at 7:12 p.m., the way she always did before the world broke. Steam ghosts the window and disappears. The chair across from her keeps its small crescent, the outline of evenings spent grading and listening. The lamp over the table leans toward an empty page, as if the room could keep doing its job if it only tried hard enough. Loneliness here doesn't whisper. It scrapes, edges like a serrated knife against the plate. The town loved Lauren because she loved it first. She ran circles when conflict sparked, not to scold, but to cool. She taught the shy to speak and the loud to listen. And when a pattern in the guidance software lit up around a 17-year-old named Tyler Grayson, cutting jokes, essays about control, Lauren didn't roll her eyes. She rolled up her sleeves. She called his mother, Evelyn, and framed it as partnership. Skills are lighter when 2 people carry them, she wrote. Come by after pickup. We'll build something you can both use. Back in the gym, the choir hums a gentle chord. A table near the stage holds small artifacts that feel like exhibits. A lanyard, a dried ink pen, a stack of Mind Matters handouts with creased corners. Aisha Coleman stands near the bleachers, not as prosecutor now, but as citizen, absorbing what can't be fit into a transcript. Community impact isn't just a phrase for sentencing. It is a room like this, stitched together by stories. Return to the house. Margaret moves with the efficiency grief requires. Cup, saucer, scarf. She keeps Lauren's gray scarf looped around her neck, not for heat, but for ballast. The phrase the girl said at the memorial, how to breathe, echoes as Margaret puts a palm on the back of the empty chair and practices. In through the nose, out through the mouth, like her daughter taught 100 frightened teenagers. On the wall by the desk hangs a corkboard, and on the corkboard, a thumbtack shaped like a coffee cup pins a small appointment card. The card is bright as a flag and helpless as paper. Wednesday, 3:30 p.m. Student T. Grayson. Purpose: check in and plan. That is the door that never opened. That is the minute the town was owed and didn't get. Margaret slides the card from beneath the tack and holds it to the lamp. The cardstock warms. The ink refuses to move. She returns it to the board, a simple act that feels like testimony. The jury will understand this. Not only a life was taken, but the next right step, the plan that would have reached for a boy, was taken with it. Detective Marco Alvarez arrived on a block that smelled of wet leaves and regular life. A cruiser idled at the curb. Protocol walked in with him. Establish perimeter, note time, preserve what still speaks. He knocked and announced. No answer. The back door sat shy of the latch by a thumbnail. No splintered jam, no pry marks. He pulled on nitrile gloves, pressed with a knuckle, and let the door open the way a book opens when you stop resisting the story. The kitchen met him with ordinary manners. An electric kettle had just clicked off, its tiny light still red. A tea bag fattened in a white cup. The spoon rested dry on a folded napkin. Steam ghosted the window and vanished. He raised his camera. Wide shot, tight shot. The living room held the outline of an evening. A pen lay uncapped beside a stack of grading. A gray scarf had slipped from an armchair and pooled on the rug. The lamp leaned toward a page. On a side table, a jewelry dish cupped a wedding band and 2 studs. A laptop hummed on its charger. The cushion on the sofa was rotated a quarter turn, a misalignment that read like a flinch. In a house that looked untouched, harm had arrived and left. He found Dr. Lauren Whitfield near the threshold of the hall. He did not narrate. He documented. EMS confirmed what his glove already told him. 30 stab wounds. He wrote the number cleanly, the way you enter coordinates you wish did not exist. 30 is not a stumble. 30 is repetition, a choice pressed again and again until it pretends to be weather. For one breath, the brutality inside such order seized him. He placed the shock on a high shelf and let training take the front seat. Near the reading chair, a small stained glass sun catcher hung in the window. Its lower corner was freshly cracked. His beam found a shard at the baseboard, no bigger than a fingernail, glinting blue and amber. He photographed it. Crime scene technician May Park arrived with a rolling case. Photos, swabs, bindle, envelope, sealed bag. Labels signed, times noted. He checked what needed checking, and only once. Deadbolt clean. Strike plate bright from regular use. Hinges true. He wrote the preliminary with nouns and verbs a jury could hold. Kitchen intact. Cup unstirred. Wallet, jewelry, laptop present. No forced entry. Victim, 30 stab wounds. Stained glass fragment recovered near window. He paused where form's pretend motive appears early, then entered what the house had already said. Signs of theft, none. Motive, none. Across the street, a neighbor pointed to the camera above her garage. With consent, officers pulled the footage and watched on a squad tablet. Rain needled the lens. At 21:45, a hooded figure slipped into frame on the far sidewalk, not hurrying, not hiding. In the sodium wash of a street lamp, the right shoulder ticked to a private rhythm. At 21:52, the figure returned in the same measured cadence, as if crossing a hallway between levels in a game. They watched again under the lamp. For a heartbeat, the hood angled up and a hint of mouth curved. You cannot arrest a smirk, but you can stitch it into a timeline. Camera, proximity, time, clothing, enough for probable cause. A magistrate signed the search warrant for the Grayson residence. The door opened before they could knock. Evelyn Grayson stood with her hands knitted at her waist. Tyler drifted into view behind her, lean in a dark hoodie. He did not ask what the warrant said. He asked how long this would take. "As long as it takes," Alvarez answered. The bedroom smelled of detergent and teenage cologne. Posters thumbtacked with indifferent precision. Alvarez kept the search spare: top drawer, closet, laundry basket. On a chair back, a hoodie hung with its sleeves collapsed like sleeping arms. The color and cut matched the figure in the video. Park swabbed a faint discoloration at the inner cuff and the collar seam, presumptive positive for blood. The garment went into paper, not plastic. The seal took a date, time, and signature. Park's eye found what Alvarez hoped it would. In the fold where cuff stitching met the sleeve seam, something glittered like a tiny thorn. Under a portable scope, it sang in bands of blue, gold, and green. A stained glass speck. Park coaxed it into a sterile dish and sealed it. Later at the lab, it would meet its twin from the Whitfield baseboard. Back downtown, the scarf recovered near the armchair had been vacuumed for trace. Among lint and life, analysts found hairs that did not belong to Lauren. 2 had intact roots and yielded nuclear STR profiles. Tyler Grayson, with a random match probability so low it felt like bedrock. Several rootless hairs gave mitochondrial DNA consistent with him, confirming contact, close and physical. Alvarez updated the intake memo with the 4 nails. Video at 21:45 to 21:52. Hoodie with presumptive blood later confirmed as Dr. Whitfield's. Stained glass microfragment from scene and cuff with pattern match. Tyler's hair recovered from the victim's scarf with STR confirmation. He did not promise miracles. He stacked choices. The arrest warrant followed. Tyler's wrists accepted the cuffs like bracelets he had expected to try on. At the precinct, the interview room was 4 walls of practical paint and a table fixed to the floor. The camera light came on. Alvarez read the Miranda warnings in the even cadence of someone who believes rights are tools, not decorations. Tyler said he understood and agreed to talk. The waiver form took his neat signature. Evelyn sat in the corner, hands tight around a tissue. She asked softly if they were sure he should speak. "He has the right to remain silent," Alvarez said. Tyler rolled his eyes. "I have the right to remain bored." Alvarez did not posture. He arranged. "We are going to be plain," he began. "We have video showing you walking to and from Dr. Whitfield's house between 21:45 and 21:52. The hoodie in your room tested presumptive positive for blood. The lab has now confirmed the profile is Dr. Whitfield's. We recovered a stained glass fragment from her living room and a matching fragment embedded in the stitching of your sleeve. We recovered your hair from her scarf." Each sentence fell like a careful brick. Silence took a chair. Tyler's eyes went to the corner of the ceiling. His mouth made the same small shape it made in the street lamp frame. Then he met Alvarez's gaze like a student awarding a grade. "You can't prove what I was thinking," he said. Not loud, not taunting, just bored. "We do not have to," Alvarez replied. He clicked the pen once. "The tape is the tape. The hoodie is the hoodie. The glass is the glass. The hair is the hair." He closed his notebook and read the time. The interview ended. That night, in an office lit by a stubborn desk lamp, ADA Aisha Coleman watched the interview on her screen. She had already sketched the trial. Video to entry, fabric to contact, glass to location, hair to intimacy. When Tyler's sentence landed, You can't prove what I was thinking. Aisha did not flinch. She let a breath rise and stop. I do not need to prove what you were thinking, she said to the empty room. I will prove what you did. She noted the timestamps, the chain, the clean links that would carry weight in front of a jury. Procedure matters, story follows. Always. She closed the file and opened a new one labeled with a date and a name. The door to trial swung into place. Arraignment gave everyone a role. The judge read the charge. ADA Aisha Coleman was assigned. Public defender Daniel Keene was appointed. Tyler Grayson answered yes like a shrug wearing sound. Detention was argued, and the ruling kept Tyler in, on paper, routine. In Keene's ribs, the first drumbeat of a longer war. In the consultation room, Keene spoke like a father who knew the rules. I'm going to say you're a kid who can still be reached, if you stop helping the other side. A smirk. You can't prove what I was thinking. Court doesn't grade thoughts, Keene said, his voice level. It grades choices. Help me show the judge your next one is different. He found Evelyn Grayson in the hallway. He won't listen, she whispered, her eyes on the holding door. He never has. Keene felt the floor tilt. A mother is a mirror and a map. Without her, his path just got steeper. Across town, Aisha drew a box on a legal pad. Intent. She told Detective Alvarez, the transfer hearing isn't a mini-trial. I'm not spending evidence. I'm spending narrative discipline. Her strategy was simple. Frame the conduct as a chain of deliberate acts. 30 isn't chaos. It's repetition, she said. And repetition is intent made visible. The hearing ran like chess. Keene's expert spoke of the adolescent brain, of a youth still malleable. He did not touch the facts. He touched the space around them. Aisha's cross of the expert was a hinge, not a hammer. Millions of adolescents have developing brains, she said. How many stab a teacher 30 times and leave without taking anything? The expert held the pause and then, very few. Capacity is not destiny, Aisha added. Accountability remains. With probation, she made the math audible. Jurisdiction ends at 21? Yes. 4 years is a short leash for violence that rehearses itself. Keene didn't call a parade of neighbors. He wanted Evelyn, but he had heard he won't listen. So he turned the argument into a promise the court could test. He is not the worst thing he has done, he said, each word set like a stepping stone. Juvenile court exists to interrupt momentum. Give us custody, programming, treatment. Give us time. Behind him, Tyler sat very still, the quiet kind that reads as calculation. Keene felt the ground tilt. Demeanor is evidence the rules don't name, but judges do not forget it. Aisha answered without crescendo. Amenability is about fit, she said. This wasn't property conflict. The house tells you what it was not. No theft, no ransack. The conduct tells you what it was. Arrival, attack, departure. The demeanor since tells you who carries the risk forward. Public safety is not protected by a clock that runs out in 4 years. The people ask for transfer. She did not list lab results. She showed the outline that makes them inevitable. The judge took the time that makes words mean. The court has considered the statutory factors, the social history, the expert testimony, and the arguments of counsel. The gravity of the charges and the nature of the alleged conduct are of the highest order. The pattern suggests planning and a sustained attack. The court is not persuaded that the juvenile system can provide protection of the public or accountability proportionate to the alleged offense within the time available. The motion to transfer is granted. This matter is bound over to the adult division. The temperature changed by a degree. Tyler's mouth tilted, the smallest victory lap ever run in place, as if adult court were simply level 2. Evelyn's eyes fled to the floor a heartbeat before her courage could follow. Keene did not flinch. He stored the loss where it wouldn't fog the next decision. He had his map now. Hold the line on culpability. Fight like hell on punishment. Across the aisle, Aisha closed her folder with no triumph, only clarity. She had kept powder dry, intent sharp, and the story standing on its strongest leg. Not what he felt, what he chose. The door to adult court stood open. Both lawyers stepped through, carrying different weights and the same certainty. The real trial would teach the town what its justice is made of. Discovery arrived like a steady floodlight, bright enough to deny shadows without blinding the room. Ada Aisha Coleman produced what the rules require and what juries later feel. Lab reports, scene photos, the neighbor's clip that pins a quiet window between 21:45 and 21:52. She read every page the way an engineer taps steel, listening for hollows, then called Detective Alvarez to walk the chain again, not to rehearse triumph, but to pressure test failure. The story had to stand on conduct, not commentary. Public Defender Daniel Keene handled the same stack like a hostile map. He traced the warrant's language word by word, tested the scope of the search, checked bag types and seal times, followed the hoodie from bedroom to lab to locker. Suppression isn't magic. It's geometry. Angles, reach, the line between within and beyond. He didn't find a break. Strategy shifted. If the facts won't leave, teach the court how to look at them. Capacity versus culpability. A boy reachable by structure, not a monster fixed in amber. Pre-trial arrived, the legal equivalent of tuning strings before the orchestra sits. Keene led with his sharpest blade, motioned to suppress the hoodie. Overbroad warrant, he argued. Seizure too swift, too sweeping. Aisha answered without heat. The affidavit supplied probable cause. The warrant named places and items with particularity. The seizure stayed within scope. Judge Celeste Monroe listened as if weighing coins. Motion denied, she ruled. The search and seizure were reasonable under the Fourth Amendment. Losing the hoodie meant Keene needed a new front. He filed a second motion with a different target and a different logic. Motion in limine to exclude the line from Tyler's recorded interview. You can't prove what I was thinking. Not hearsay from a stranger, but a defendant's own words, yes. Still, Keene argued, the sentence is a spark near dry timber. Its probative value drowned by unfair prejudice unless and until the defense opens the door. It invites the jury to punish attitude, he said, not to weigh evidence. Aisha did not overplay it. The statement shows consciousness of the law's reach, she answered. It is not a confession, and I won't sell it as one. But it is relevant to the chain of deliberate choices. She could have pressed harder. She didn't. Monroe drew the line where trialcraft lives. Granted in part, the judge ruled. The statement is excluded in the people's case in chief, admissible if the defendant testifies or if the defense opens the door on state of mind, remorse, or intent. A clean, practical ruling, and a trap that sprang quietly. If Keene put Tyler on the stand to humanize him, Aisha would get the line for free. If he didn't, the jury would never hear the sentence that most reveals the boy's weather. Strategy isn't about liking choices. It's about ranking them. With the legal scaffolding set, the case stepped into voir dire, the long conversation where conscience gets measured. The panel looked like the town: warehouse foreman, retired nurse, bus driver, para-educator, people who know the sound of clocks and rent. Judge Monroe gave the oath and a refrigerator door admonition. Feelings are weather, verdicts are buildings. Use only materials you receive in this room. Phones away. Headlines ignored. Heartstrings parked until evidence speaks. Aisha's questions cut clean and quiet. Who here works with teenagers? Hands rose. Can you hold empathy in one hand and accountability in the other without dropping either? Juror 4, a school counselor with a careful haircut, nodded. Every day. I know the difference between a mistake and a campaign. Aisha let the sentence hang like a level finding true, then moved on. Comfort with forensics, attitudes toward police and prosecutors, whether silence from the defense table would feel like a confession. She listened for patterns, not performances. Keene took the floor with a mirror tilted another way. Can you imagine a 17-year-old who is both responsible and reachable? He asked. Juror 7, a Little League coach who also runs a forklift, spoke about rules and second chances in the same breath. Keene walked the panel through patience without promising absolution. If the law tells you to separate feeling from proof, can you do it even when you ache? The yeses came without pride, which is the only kind that counts. Challenges moved like chess without pointing fingers. Aisha asked for cause where bias was bright. Keene spent peremptories where bias hid behind polite phrasing. The 12 that remained made statistical sense and moral sense, which is rarer than lawyers admit. Alternates took their chairs like understudies who know the script. Between questions, Aisha checked her outline, the way a pilot checks a runway. The hoodie stays, the glass stays, the hair stays. The interview line waits behind a door marked "Defendant testifies." She would not drown the panel in jargon. She would stack simple things until they became heavy. Arrival, attack, departure, an untouched house, and let the jurors feel the weight gather. Keene reread the judge's ruling and felt the dilemma settle like a stone. To humanize Tyler, he might have to let the worst sentence in the case walk in wearing the state's badge. He underlined a different path: experts, family context, the scaffold of juvenile treatment, and circled one word twice: credibility. If the jury doesn't believe your solution can hold him, they will build one of their own. Then came the small, mean weather, no transcript records. Deputies stood to lead Tyler out. Under counsel table, 3 quick snaps sounded, fingers clicking in a syncopated rhythm meant for no one but himself. Keene heard it and let out a breath that did not move his chest. Coaching would be hard. Across the aisle, Aisha saw the motion and returned to her notes. A tick is not a confession, but climate accrues from ticks. Court recessed, the room emptied the way a stage clears before the curtain goes up. On paper, nothing dramatic had happened. Discovery exchanged, one motion denied, one partially granted, a jury chosen. In fact, the trial had already begun. One lawyer had kept powder dry. The other had learned which tinder might catch. The next time they met this panel, bricks would replace blueprints. And every choice from here on: who speaks, who stays silent, which door to open, would echo louder than any line of dialogue. The first morning of testimony tightened like a lens. The jury settled. Pens hovered. ADA Aisha Coleman rose without flourish and called her first witness, the neighbor whose garage camera seized the block. The foundation would be simple: time, fabric, glass, hair. She would stack ordinary things until they turned heavy. On the screen, rain stippled the frame. At 21:45, a hooded figure entered, not hurrying, not hiding, hands tucked. Under the street lamp, the right shoulder ticked to a private rhythm. At 21:52, the figure returned in the same cadence. A route walked, not fled. Aisha said little. She let the clock talk. Public defender Daniel Keene clipped the edges on cross. Could she see a face? No. Was the distance and rain a problem? Yes. Could that gate fit others? Of course. On redirect, Aisha asked one question. What made you call the police? The neighbor pointed at the timestamp and said, he didn't run. The lab analyst came next with the hoodie taken from Tyler's room. Tests found blood at the cuff and collar. Full DNA comparison said the blood was Dr. Lauren Whitfield's. Not a rumor, not a guess. A match. Aisha translated the math for the room. You don't expect to see this twice in a lifetime. Keene's cross was respectful and sharp. Paper bags, not plastic? Yes. Seals intact? Yes. Could a tiny smear travel by accident? In theory. But the pattern here, the analyst said, made sense for close contact. The jury wrote. Theory drifted, proximity stayed. The trace witness brought 2 pictures and a light box. One photo showed a colored speck taken from Lauren's living room floor under the cracked sun catcher. The other showed a speck pulled from the stitching at Tyler's sleeve. Side by side, the colors and lines matched. Same kind of glass. Same source. Keene asked the one question that mattered. You can't say they touched, only that they came from the same piece. Correct. Aisha let the point breathe, then said, glass doesn't ride on ideas. It rides on fabric. The jurors nodded because their shirts were sleeves, not theories. The scarf entered like a soft witness. The hair examiner explained it plainly. Hairs that weren't Lauren's were lifted from the fabric. 2 with roots gave exact DNA matches to Tyler. Others, even without roots, still pointed to him. In regular words, his hair was in her scarf. That means physical contact. To give the evidence a human floor, Aisha called Principal Rebecca Sloan. The school calmed when Lauren worked. Sloan said. She kept a kettle in room 214 and stayed after hours so students could park their storms. She called parents, including Tyler's, to make plans, not scold. She made hard days survivable. Maya Chen, a junior, took the oath like it weighed something. She told the jury Lauren taught her how to breathe when panic made hallways tilt. Cocoa steam, soft chairs, straight talk. Empathy was not a slogan. It was a practice. She said the word and looked at Tyler. He smiled like it was a joke. Aisha then called the guidance counselor who had flagged Tyler months before. Patterns, she said. Cutting jokes aimed at smaller kids. A need to control group projects. A habit of turning apologies into negotiations. Nothing charged, but the shape was clear. Lauren had scheduled a check-in with him for the next day. A classmate followed. Sleeves tugged to his wrists. He remembered Tyler's game talk, boss fights, levels, and how some teachers were obstacles to clear. He described Tyler counting tiles on the floor during detention and whispering, 30 is a good number, like he was choosing reps at a gym. The room chilled. Detective Marco Alvarez took the stand with the steadiness of a man who respects rooms like this. He described the kitchen's ordinary manners, the kettle off, the cup unstirred, then the living room's small wrongness, the cushion turned a quarter. He told them about the body, and he said the number out loud, 30. He explained the camera clip in ordinary words. A figure walked in at 21:45 and walked out at 21:52, not running, not hiding. He explained how the hoodie was collected, how a tiny colored fleck was lifted from the sleeve, how the scarf gave up hairs that weren't Lauren's. He did not dramatize. He simply placed things. Keene rose for cross with measured calm. You never recovered the weapon? Correct. You never got a confession? Correct. You cannot tell this jury what my client was thinking that night, can you? Alvarez answered the only lawful way. Correct. The words hung like a door left ajar. Aisha asked for a sidebar and reminded the court of the earlier ruling. The defense had opened the door on state of mind. Judge Monroe nodded and gave a careful instruction. The upcoming clip was not a confession. It would be admitted only to answer the defense claim about proving what someone was thinking. The screen filled with the recorded interview. Tyler leaned back in a chair and let a thin smile ride his mouth. His voice was flat, almost bored. You can't prove what I was thinking. Aisha paused the frame. She turned off the sound. She said nothing. The silence did the work. A campus security monitor took the stand next. He was not there to sling mud. He brought logs. 2 months before the killing, he wrote up an incident where Tyler blocked a freshman in a stairwell and made the boy apologize for getting in my line. No punch. No shove. Just control wrapped in a smile. The write-up ended with Lauren's name. She had followed up, scheduled a talk, and walked the freshman back to class. A technology teacher testified about group projects. Tyler volunteered to lead and then rewrote other students' parts without asking. When corrected, he framed the correction as a challenge. He liked rules as long as they were his. The class laughed sometimes. The teacher did not. He had emailed the counselor. Lauren had replied within an hour. Judge Monroe cautioned the jury with another boundary. These school incidents were not charges. They were context. Use them, she said, only for what they show about planning, control, and the path to that house, not to decide character by rumor. The line held. The jury kept their pencils moving. Across the day, Tyler's body language wrote its own margins. When empathy surfaced, the corner of his mouth twitched, a private joke, he told himself. When the number 30 landed, nothing moved. Juror 4, the counselor, boxed another note. Juror 7, the coach, wrote 2 words, control issues, and underlined them once. None of it was evidence on its own. All of it was weather. And weather, when it doesn't change, tells you what the climate is. Aisha's cadence stayed the same from witness to witness. Short questions, clean answers, long pauses that let the pieces lock. She never used the word motive. She did not need it. She used verbs. He walked in. He made contact. He carried glass out. He left his hair behind. He walked home. The house stayed neat. The valuables stayed put. The number stayed 30. When she looked at the jurors, she did not ask them to feel anything. She asked them to see. By late afternoon, the case-in-chief felt like a building you could lean against. It wasn't ornate. It was load-bearing. Aisha checked her outline and closed the folder with a small click. The people rest, subject to recall. The words settled like bricks. Keene stared at the blank half of his pad. If he put Tyler on the stand, that 5-second line would walk back in unchained. If he didn't, The jury would never hear his boy speak. He chose silence, for now. The defense opened with steel, not softness. Daniel Keene stood before the jury and cut a line through the air with his hand. "The law separates the broken from the breaking," he said. 17 isn't an excuse. It's a condition the law cares about. Measure him. He did not promise an angel. He promised a boy who could still be steered. He called a developmental psychologist who spoke in working words. At 17, the brakes are late. Impulse control and foresight are still under construction. Structure helps. Treatment helps. Time helps. Keene used it like scaffolding. When a bad decision erupts, he asked, how good are teenagers at stopping themselves midstream? The expert kept it careful. Adolescents struggle to interrupt themselves. They escalate. Ada Aisha Coleman rose with a single blade. "Millions of adolescents struggle," she said to the jury. "How many of them stab a teacher 30 times and leave without taking a thing?" The pause held. "Very few," the expert said. "Very few," Aisha repeated, and sat. The room felt the word intent without hearing it. Keene pivoted to the future. He called a clinician from juvenile custody, someone who fixes patterns, not people. The clinician explained tools in everyday terms, breathing drills that become habits, rehearse anger backward, coaching that turns a must into a can. "With participation," he said, "you see change." Keene pressed. "With a kid like Tyler?" The clinician exhaled. "With participation." Aisha stepped back in, economical. "Participation is voluntary," she said. "What happens when the habit isn't rage but control?" The clinician cited outcomes. Youths with grandiosity and contempt for limits fail more often and sooner. Aisha leaned forward just enough to signal precision, not drama. "Doctor, based on published outcomes and what you reviewed here, discipline notes, the interview demeanor, is a cooperation-based model a poor clinical fit for someone who believes he has nothing to change?" The clinician did not overreach. "It presents a significant challenge." The phrase sat like a scale, its weight now visible. Keene turned to context. He offered school records with blank squares where counseling was missed, a father on the road, a mother working 2 jobs and tending an aging parent, a kitchen table where arguments sounded like weather and no one walked them back. He was not asking for absolution. He was asking for oxygen. "Systems fail in inches," he told the jury. "So do kids." He called small witnesses who had seen 2 Tylers. A shop teacher described a student who could lead a team, then quietly rewrite everyone's work to make it his. A neighbor remembered a boy who shoveled snow without being asked, and later glared when corrected for trampling a flower bed. Keene didn't varnish it. "You saw both boys," he said. "We all did." Aisha's crosses were surgical, verbs only. When he led, did he ask or take? "Take," the teacher said. When corrected, did he repair or retaliate? "He made it uncomfortable," the neighbor admitted. Aisha turned to the jury as if handing tools, not feelings. Ask. Repair. Those are choices. Take. Retaliate. Those are choices too. Between witnesses, the real fight moved under the table. Keene whispered, "Look at them as people. Keep your face still. Answer nothing unless I ask." Tyler watched the clock, then let a corner of his mouth climb when he heard the word empathy. Juror 4's pencil made a box. Juror 7 underlined control issues. Behavior isn't evidence, but it teaches the eye what to believe when evidence arrives. Keene considered calling Evelyn. A mother can bridge what a son burns. In the hall, Her voice trembled on 4 words that end strategies. He won't listen. Keene nodded and closed the folder. He would carry the weight himself. He tried to reclaim the center with a clean argument. The state built a chain, he told the jury. We don't pretend it isn't heavy. We ask you to notice what's missing. Purpose. No theft. No ransack. This looks like escalation, ugly and fast, more than execution. He held their eyes. 17 means measure carefully. Aisha stepped into the pocket he had opened. The law lets you infer intent from conduct, she said. So let's look at conduct. She ticked the beats with an open palm, not a finger. Walks in at 9:45, walks out at 9:52. The house stays neat, nothing is taken, and the count climbs to 30. She paused. That's not escalation. That's a sustained exercise of control. She let the room feel the word. The defense says the purpose is missing. Purpose isn't always loot or revenge. Sometimes purpose is the performance. The only thing he participated in that night was proving he could. Keene returned to the clinician for the lifeline called possible. You can't diagnose from the stand, he said. You can tell the jury what's possible. Possible remains, the clinician agreed. Aisha pared it thinner. Possible is not proof, she said. Hope is not a defense. She sat and gave the jury the gift that sharp arguments always need. Silence. Tyler did the rest without speaking. When the scarf surfaced, his jaw moved like a bored hinge. When the number 30 returned, his gaze followed the second hand, not the testimony. Keene's knuckles whitened around a yellow pad he could no longer use. He had told his client how to look like someone who deserved a second draft. The boy looked like a player waiting for the next level to load. The defense rested. The words fell with the quiet of a door closing in a house that's already empty. In the holdover corridor, Keene tried one last coaching rep. At sentencing, say nothing, he said. Let me speak. Contrition you don't feel reads as contempt. Tyler's smile was a paper cut. We'll see. Choice again. Back in the well, Aisha capped her pen and placed it parallel to the folder's edge. She did not look at the defendant. She looked at the 12 people who would decide what the town believes about harm and choice. Keene stared at the chair where his next witness should have been. He had given the jury science, context, and the possibility of change. She had handed them verbs: walk, choose, stab, leave, and a frame the law trusts: intent inferred from conduct. The jury would carry a hard pairing into deliberations: a child's brain and an adult's pattern, a family's inches of absence and a teacher's mile of presence. Upstairs, the hallway smelled of lemon polish and rain-off coats. The storm moved into the jury room. The courthouse listened for what kind of weather they would make. The defense had rested. Judge Monroe glanced at the clock to set closings, and the room loosened, until Evelyn Grayson stood. No one called her. She rose from the second row like a person climbing out of deep water. Your Honor, she said, steady and small. May I be heard? I should have said this earlier. A breath passed through the gallery. The judge looked to counsel. Aisha spoke once, precise. The people moved to reopen for a single limited witness at her request. Scope confined to parental reinforcement and the scheduled meeting with Dr. Whitfield. Keene did not oppose the right to speak. The court swore Evelyn and gave the jury a short boundary: limited purpose, not character. Then the room belonged to her. Her decision had not begun in this minute. It had started the night of the arrest. Hands on glass in a visitation room where her son leaned back and smiled at the rules. It had continued under a ceiling light in the public defender's office while Keene said, "Silence is the smart play," and Tyler rolled his eyes. It had followed her home to a kitchen where the voicemail from Dr. Whitfield repeated in her head. The one she deleted about tomorrow after last bell. It had sharpened in court when she watched her son treat the proceedings like a game board, when she heard him on a screen say, "You can't prove what I was thinking," and saw no change in his face. And it had snapped, the last thread, when Aisha said 30, when the mother in the gallery closed a hand around a gray scarf, and Tyler, her Tyler, smirked as if he'd just cleared a level. Evelyn did not begin with tears. She began with a ledger. "I am his mother," she said, hands laced in her lap, "and I taught him the wrong lesson." She looked at the jurors. 2 months before she died, Dr. Whitfield called me. She asked me to partner with her. I deleted the voicemail and told myself it was a kindness. The words were plain, the kind that clean instead of flare. There was a warning letter about a stairwell incident. I tore it in half at the sink. A neighbor's mailbox got knocked over. I pushed cash under their door with a note that said, "Anonymous," and told my son the wind must have done it. Her voice set a rhythm. I deleted the call. I tore the warning. I paid the damage. I said, "I'll handle it." And I called that love. She didn't look at Tyler. She looked at the floor like she was reading the fine print of her own life. Every time I saved him, I taught him that consequences belong to someone else. I turned our home into an appeals court where not my boy was always in session. She drew a breath that sounded like a door opening. I praised clever when I should have praised kind. I taught him that a smile is a password to every rule. Say empathy, and he grins like he just cleared a level. That grin is my lesson, not his nature. She lifted her eyes to the 12. If you have ever wiped away a consequence and called it love, I know you. I am you. But love doesn't remove weight. Love puts the right weight back where it belongs. She swallowed. Dr. Whitfield invited me to help. I canceled. The meeting was for the day after she died. I cut the bridge before he could cross it. Her hands unclasped, then closed again. I thought I was protecting him from the world. I was protecting him from himself. That is what I regret. Only then did she turn toward the defense table. I heard him say, "You can't prove what I was thinking. I am the one who taught him that winning matters more than owning what you did." She faced front again. I am not here to hurt my son. I am here to stop hurting others through him. She held still as if learning how. Today, I choose justice. The chair legs scraped hard. Tyler surged up, the table skidding an inch. Liar. He lunged 2 steps toward the stand, voice cracking on fury. Don't you say that? Bailiffs had him by the elbows in a practiced grip that made noise but not injury. Evelyn did not step back. She stood like a person taking her first unborrowed breath. Keene reached his client's shoulder and said low, "You just testified without swearing." Aisha did not move. Conduct was making her point for her. Juror 4 drew a box and wrote 2 words, "No remorse." Juror 7 underlined control spillover and put down his pen. Judge Monroe tapped the gavel once. "Members of the jury," she said, level and calm, "you will disregard the outburst and decide this case only on evidence admitted." She called a brief recess. The room emptied like lungs. Order returned with the clock's second hand. "Mr. Keene," the judge said, "cross?" He rose carefully, the way a surgeon lifts a tool he respects. He did not attack her. He tested the edges of what she had laid down. "Mrs. Grayson, grief can magnify. Are you certain you're not enlarging your part in this?" Evelyn's hands found each other. "I'm not enlarging anything," she said. "I'm stepping out of the way." He asked the question duty requires. "Are you trying to save yourself?" She met him without heat. "I'm trying to stop saving him the wrong way." He nodded once. No further questions. The judge renewed the boundary in a single clean line. The testimony is received for context, pattern and reinforcement tied to the missed meeting, not for character. The panel nodded. Boundaries keep trials from becoming bonfires. This felt like a contained flame. Evelyn stepped down. She passed within arm's length of her son and did not reach. He stared past her, breathing hard, jaw locked, fury showing where indifference used to sit. At counsel table, Keene arranged his notes, measuring what mitigation had just lost. Not a confession, not a diagnosis, but a map of inches. Each small rescue, each forgiven cut, pointing to a night when there was no more world left to stand between the boy and the weight his mother had carried for him. Aisha made a brief record of the voicemail transcript exhibit, then closed her folder without comment. She looked at the 12 people who would carry all of this into a small room and turn it into law. In the gallery, Margaret Whitfield held a gray scarf in both hands, the way you hold a photograph. The second hand on the courtroom clock stepped forward. A mother had moved a burden from her shoulders to where it belonged. Whether the law would hold it, there was no longer a question for her. It was a question for them. The jury took the case in whether you could feel. 12 chairs scraped back. 12 people disappeared behind a door that locks from the inside. Tyler walked in changed. The smirk that used to greet the word empathy was gone. What remained was a brittle calm, the kind that cracks when touched. Aisha sat with a closed folder and an open gaze, letting the weight of the record rest on the plainest facts. Keene leaned against the wall that has steadied more lawyers than it has saved, saying nothing. Evelyn stood beneath the portrait of a long-dead judge, fingers laced in a prayer that had finally learned how to be honest. Margaret Whitfield held a gray scarf and looked out at rain that remembers names. They were out just about an hour, 59 minutes, longer than hope allowed, shorter than doubt expected. The buzzer sounded. The room refilled with the soft commotion of lives being measured. Tyler took his chair without looking left or right, jaw locked, eyes set on the middle distance like there was a level he could still unlock if he didn't blink. "Madam Foreperson," Judge Monroe said, voice even, "has the jury reached a verdict?" "We have." "On the charge of murder in the first degree, how do you find?" "Guilty." The word landed like a stone finding its bottom. Tyler's practiced calm broke the way glass does when the hairline finally gives. A sharp breath, a near laugh that wasn't a laugh, and then nothing. Juror 4 exhaled through her nose and set her pencil down. Juror 7 watched the defendant the way a coach watches a player who has finally run out of plays. Aisha did not move. Keene's jaw flexed once and found stillness. The court polled the panel. The eyes were steady. Judge Monroe thanked the jurors and set sentencing for the week ahead. Sentencing morning belonged to a quieter crowd. For sentencing, Tyler appeared in County Orange, wrists uncuffed at counsel table but custody plain in every seam. The courtroom smelled faintly of lemon polish and wet coats. Sentencing is not a second trial, it is a weighing, and scales need stillness. The judge had read memoranda and letters, the thick paper where people try to keep a person on a page. Victim impact came first because the law says it does. Margaret stood with the scarf folded like a promise in her hands. Lauren was not a headline, she said. She was the voice that told me which tea to steep when the world was loud. She was the text that said, "Save me a seat. I'm 5 minutes late." She kept a kettle in her classroom so other people's storms wouldn't spill into harm. She did not ask for vengeance. She asked for weight to be set where it belonged. If mercy and justice are sisters, she said, then mercy today stands beside justice, not in front. Principal Rebecca Sloan spoke next, for the school that still carried Lauren's habits. "We lost a person who prevented 10 harms for everyone we can count," she said. "We lost a practice, not just a presence. Our students learned a new word this year: aftermath. Please ensure it doesn't become our curriculum." Her eyes did not touch the defense table. They faced the bench that decides how the town moves forward. Keene rose into a room that had learned what weight feels like. He did not relitigate. He spoke of law's rope for youth, structure, treatment, the scaffold that can interrupt momentum. He asked for life with the possibility of parole. Punish what's measurable, but leave a door. He did not look at his client when he said it. He looked at the idea of him, as defenders learn to do when faces are working against them. Judge Monroe turned to the defense table. "Mr. Grayson, you have the right to speak before sentence is imposed." Tyler lifted his chin. "I don't have anything to say." The words were shaved to keep from touching anything. He did not apologize. He did not explain. He did not look at Margaret. Absence can be its own statement. Aisha wrote nothing down. The judge took the time that makes words mean. "The law requires this court to consider youth and its attendant features," she began, each phrase placed like a brick. "Your age at the time of the offense, your family context, your capacity for change, your behavior before, during, and after the crime, the brutality of the offense, the risk you pose to the public, and the impact on this community." She let her gaze move without accusation. "I read your mother's statement. I listened to your lawyer's request for a door. I watched you throughout these proceedings. What the record shows is not an impulsive loss of control. It is a deliberate exercise of it. You walked to a teacher's home at 9:45 and left at 9:52. You did not take a thing except a life. You repeated your choice 30 times. You treated the aftermath as performance. Programs built on cooperation require what you have declined to show." She folded the law's caution into the facts. "The Supreme Court instructs that life without parole for someone your age must be rare and reserved for those whose crimes reflect irreparable corruption. Before imposing such a sentence, a court must seriously consider youth itself and what comes with it. I have. I weighed your age, your history, the possibility of change, the treatment available, the time limits of juvenile systems, your demeanor, including your outburst and your refusal to face the harm you caused, and the extraordinary damage inflicted on this community. A breath that felt like a page turning. A term of years with parole does not protect the public, does not honor the gravity of this offense, and does not reflect the sustained nature of your conduct. This is one of those rare cases. She set the decision down like a cornerstone. It is the judgment of this court that you be sentenced to life imprisonment without the possibility of parole. The sound in the room was not an intake, but a change in pressure. Tyler blinked hard. The boy who had always found a way around finally met a rule that did not move for him. Keene set a hand on his shoulder, professional and human in the same touch. Evelyn did not cry. She sat very straight and kept her hands folded, like someone who had remembered how to carry only her share. Aisha gave one small nod, the kind that says the structure held. She shook Keene's hand because the work is cleaner when adversaries honor it. Outside, the rain had thinned to a silver mist that made the courthouse steps look newly washed without erasing what had been carried up and down them. Alvarez stood off to one side, coat collar raised, the posture of a man who knows that victory in his line of work is mostly the absence of a new harm. Reporters talked in the hush they use when grief is close. Margaret stepped forward and took Aisha's hand, not to lift it, but to hold it like a rail. "Thank you," she said. Aisha answered the truth. "For telling the truth," she said, and meant the mother on the stand, the principal with the kettle, the jury with the pencils, the judge with the balance. Evelyn stayed beneath the portico, half in the weather, half out. No microphone reached for her. None would have helped. She watched the square where kids cut across the grass even when signs asked them not to, and she finally understood what a boundary is for. Not to keep people out, to keep them safe when they go in. The lesson was not soft, but it was clear. Love that erases consequence is not love, it is delay. Delay grows teeth. A teacher who taught a town's children how to breathe deserved a world that could breathe without her. Today's sentence was not a story about anger. It was a story about weight set back where it belongs. If you're listening and you've ever smoothed a lie for a child and called it care, hear this as a gentler verdict you can still accept. Stop saving in ways that teach harm. Partner with the people who reach out. Make empathy a door that opens to accountability, not a password that bypasses it. We will keep telling these stories, the ones where law is a hinge between pain and principle, where a community learns what it stands for. If this moved you, share it with someone who needs the reminder. Subscribe to follow the series and carry the conversation to your town, your school, your kitchen. Justice repays truth. Truth requires courage. Courage is a habit we can teach. And when we teach it, a verdict like today's is not vengeance. It is order restored. Inside, the clock kept its slow, faithful count. Outside, the mist lifted and returned, a soft reminder that weather changes and the work remains. Aisha walked down the steps beside Margaret, their hands briefly linked. Two women carrying different weights, both finally set down in the right place. The law had spoken with both its heads, the strict and the humane, and in that balance, a town found the shape of itself again.